All right. We want to welcome everybody, and we know we have folks logging on, and we also had a lot of folks sign up, and they'll be getting a copy of this video that we are recording and will be available next week sometime. But we want to thank you for joining us this evening on a free legal webinar, and we're going to be talking about a topic where there's two cases for the U.S. Supreme Court regarding the use of social media and something that board members should be aware of. And we want to first thank our administrative director for the Nassau-Suffolk School Board Association, Ms. Lorraine Mentz, who's handling logistics, logging folks in. Want to let you know that during the presentation, if you have a question or a comment for our presenter, Mr. Howard Miller from Bond, Schoeneck and King, please enter it in the Q&A box, and we will be monitoring those questions as they come in, and we will be asking them during the presentation so that you can get the information and Howard could answer it as we are going along. So don't be shy. We want this to be as interactive as possible. And, well, I also want to give an introduction to Mr. Howard Miller, who has agreed to put this presentation together for us today and take time out of his busy schedule. He is an attorney with Bond, Schoeneck and King, and Howard Miller has been involved in education law for, well, longer than the Vikings have ever won a Super Bowl. Well, no, not that long. That's a long time. They've never won a Super Bowl, but Howard is a big Minnesota Viking fan. So he and I go back and forth about our terrible teams that we root for. We're just gluttons for punishment. But Mr. Miller is a well-experienced school law attorney, and Bond, Schoeneck and King obviously represents a lot of schools across New York State, and their practice covers more than just education law. They cover labor law, all sorts of stuff, real estate, taxes. It's a very big firm, but I had actually seen Howard do this presentation or co-present on this topic at the New York State School Board Association's annual convention if you weren't there, but I felt it was important enough to highlight it for us locally here. So that's why your association, the Nassau-Suffolk School Board Association locally, decided to put this together so that we can address these cases that are before the Supreme Court, discuss what board members should know, best practices, and again, during the presentation, if you have a question, don't hesitate to put it into the Q&A so that we can just, answer the questions as we go along. So without any further ado, I want to welcome Mr. Howard Miller. Howard, thanks for joining us and all of our members. And we see the picture of your dog back there. We know that you're a big animal lover as well. And again, on behalf of the Nassau-Suffolk School Board Association, its board of directors and officers and our members, thanks for putting this together for us tonight and bringing us this important information.
Thank you, Bob. So good evening, everyone. Earlier today, someone reminded me of an episode of the show Curb Your Enthusiasm, where Larry David says to another character that once you get more than 3 days into January, it becomes too late to wish other people a Happy New Year. Now, as much as I love the show, if there ever came a time where Larry David became the gold standard for social etiquette, I think the Earth would probably spin off of its axis and out into oblivion. So I will, in fact, wish you all a Happy New Year. And of course, what better way to kick off a new year than to talk about new and different ways that social media can give us all agita. And we do have 2 cases going up to the Supreme Court. Now, as Bob mentioned, I did co-present on this up at the School Boards Association's convention. I had the privilege of co-presenting with a really brilliant lawyer named Frank Miller, and
No
great
relation.
thing, no relation. And the great thing about presenting with Frank is that when someone from the audience asked a relatively easy question, before Frank could talk, I would jump in and answer it, thereby creating the impression that I knew everything there was to know about this topic. But if somebody asked a really difficult question, I could play the part of the gracious co-presenter and defer to my esteemed colleague, Frank Miller. So if when Bob reads a question, if there's a long pause, it's because I am texting Frank to get the right answer.
And I am
But
certainly not an esteemed colleague and jump in on that
yeah,
answer. So
exactly. But before we get into the topic, I want to give you a little brief background of my own kind of legal history with social media, because it does inform how I view all of these issues. So when I was first out of law school, I happened to work for one of the really mega Wall Street law firms, and they had, for what was at the time the state-of-the-art technology. But that technology at the time did not include, there was no email, there was no cell phones, there was no internet, there was nothing like that. My children kind of think of that as the dark ages. And the image I think they get in their head is of people walking around in medieval cloaks. Um, there's no electricity, the streets are all muddy, there's livestock going all over the place. And I think that that's how they view the pre-internet era. And I do try to remind them that things weren't exactly all that bad. We did have mechanized modes of transportation. We did have TV and restaurants. But when I mentioned that we had stores back then, that's when things get a little dicey, because I tell them that there was actually a time before you bought something, you went in and you tried it on. And this younger generation finds that to be just appalling, and they can't wrap their arms around it. But as we fast forward, when I became a school attorney, I remember when the internet was kind of in its infancy, and going to a conference and speaking to a very smart attorney named Richard Gercio. And I asked him, what do you think about all of this? Where do you think this was going? And he did say, look, I think that this is all going to be fine, and there's going to be really good things that come of this. But I do have a concern that the internet is going to become, and then I'll never forget this expression, a playground for idiots. And I have to say, over the course since that conversation, I have really seen that. So it
Is
is
that the
very
legal
common.
term, by the way? Playground for idiots?
It is in the law books.
Okay,
And
good.
so it is very common for clients to send me links to things that they want me to see. And they're never wholesome links. They're never a link to a group of golden retriever puppies running through a meadow or sunset over Key West. They normally involve some sort of X-rated conduct by the part of employees. And what will happen is that I will go to click on the link. My firm's internet filters will block it. I then have to call our IT department, and the person on the other end will say, Howard, this is the fifth time this month you've asked us to block a porn site. We are begging you to get some help for yourself. And I do try to explain to them it is all work related. I don't know whether they believe that, though.
Well, you
Um,
shouldn't be opening them emails up at 2:30 in the morning, though, Howard. That gets a little
I think
suspicious.
that's the problem. It's a little iffy. So now these two cases that are before the Supreme Court, they have to do with the personal Facebook pages of, in one case, school board members, in another case, a city manager. And the questions before the court is, at some point, did those personal Facebook pages become almost a branch of the public entity itself? And if it had become a branch of the public entity itself, that means that the host of the Facebook page cannot engage in what we call viewpoint discrimination. So what does that mean? So in a pure First Amendment case, and this is one of our most cherished freedoms that we all believe separates us from other countries, is that we have this right to free speech. And when government, whether it be a school board, a town, the United States government, creates a space for people to come and express their opinions, government can't censor those opinions with which it disagrees. So some of you may have had occasion, I'll give this as an example, of taking the Long Island Railroad during the election seasons. And you may find yourselves having to run a gauntlet of people handing you brochures from political candidates. Now, if the MTA had a rule that just allowed that, anyone could come and deliver pamphlets. It couldn't make the rule such that only members of the Democratic Party could do it, or only members of the Republican Party could do it. That is viewpoint discrimination. By the same token, let's take a look at the public portion of a school board meeting, and the budget is being discussed. The school board, when it allows public comment, can't say only those people who are going to say something good about the budget can talk. It can't discriminate against people's point of view. So it can't say a government agency, once it creates a public space, can't say only people who agree with our point of view can express their point of view. It has to be open to everyone. So what the court is grappling in these cases is, did in fact, by virtue of the way the board members were creating their page, make it so it was a public forum as opposed to their own private page. So if we could switch to the next slide. So the two cases, one is out of the Ninth Circuit in California. The other is out of the Sixth Circuit, which sits in the Midwest. And in the California case, you had two board members who created a public Facebook page and Twitter pages to promote their campaigns for office. Once elected, they continued to use these social media pages to inform constituents about the board's activities. So if we can go to the next slide. So, oh, sorry, we went through. So two parents of children in the school district frequently left comments critical of the trustees and made disparaging remarks about the board. Fortunately, we would never have to worry about that on Long Island because we know how much everyone is so gracious and kind to school board members.
I usually get just those comments from family members.
Right. So the trustees eventually blocked these parents entirely from their social media page and the family sued. And if we can go into the next slide. So following a trial, a federal district court agreed with the plaintiffs that their First Amendment rights had been violated, that these trustees had engaged in viewpoint discrimination. The board appealed to the Ninth Circuit, which upheld the findings of the district court and also concluded that the board members had violated the First Amendment. So if we can go to the next slide. And I'm going to talk a little bit in more detail about this case, just laying out the different facts of the two cases first. In the second case, there was an opposite conclusion. And in this case, you had a city manager in Michigan, had a Facebook page, which he listed his roles as a father, a husband, and a city manager. He posted mostly about his family on this page. Now, this city manager actually had more than 5,000 friends on Facebook. I have about 6 friends on Facebook. 4 of them I had to pay to accept my friend invitations, and the other 2 are inmates for whom I did a pro bono case. So, to have 5,000 is pretty amazing. So go to the next page, Pete. So, occasionally, this city manager posted things about his job. And posted information about the city's policies. But the key word there is occasionally. It wasn't the main purpose of his Facebook page was private. So if we can go to the next page. So you had a resident who didn't approve how the city manager was handling the pandemic. He began to write criticisms in the comment section. Eventually, the city manager blocked him from the Facebook page, and the block prevented this resident from commenting on the page. So the resident sues, and the federal appeals court rules in favor of the city manager. The reason being is that the primary purpose of his Facebook page was personal, and the fact that he only occasionally posted things about work did not transform this into a public place. So can we go to the next page? And we can skip one more slide. So let me just give you an analogy. So I have my own Facebook page. I would strongly encourage you not to check out that page. It is quite boring. I mostly post things about my dog Bella over there, which frankly annoys my cat Oliver. But let's say I would have posted on my Facebook page that I'm going to be speaking at this webinar tonight. Does that really transform my page into a page of my law firm? I don't think so. And I think that's one of the things that the court looked at. And if we can go to the next slide. So the case is heard oral argument on October 31st of this year. There will be a ruling. I'm sorry, the case has gone up to the Supreme Court, both cases. The court heard argument on October 31st. Typically, they rendered their decisions in June. Now, most of you will be aware that in some high-profile cases before the Supreme Court, we see a split between the liberal bloc and the conservative bloc, and you can kind of tell where they're going at oral argument. In this case, there was not that kind of split. The court, both sides of the equation, were really struggling with how do we create rules to govern this? When does this all of the sudden, when someone has a social media page that ostensibly is private, become public? If we can switch slides.
Now, I have a quick question for you, Howard,
Sure.
right? So, as board members, when we are acting as board members and carrying out the actions of the district, if we are sued, it is covered by the district, and we have our school lawyers represent us and everything else. We're not personally exposed. In this case, are board members or are the two board members possibly seeing personal exposure, or is the distinction because it's being viewed as an official page, does it still fall under the realm of actions as a government official?
Yeah, I would take the position in most cases that we should indemnify board members. I think the only reason that would be different, I think if a board as a whole were to say to two board members, you're crossing lines here, and we're asking you to stop, we might say you were acting outside of the scope of your members, your role as board members. Hopefully
And we'll
these
get
things
into best
wouldn't.
practices later
Yeah,
on.
hopefully
Yeah.
these things wouldn't come to that, and we'll have a discussion about that. I don't think anyone wants to be sued over these things, and we'll talk about some pragmatic ways to look at this. So let's go one more slide. So the reason why the Ninth Circuit ruled the way it did is that the trustees really held the page out to be acting in their capacity as trustees. So they solicited input from constituents on all types of district matters, the superintendent search, budgetary matters, policies. So they created really an adjunct of their role as board members on this social media page. So if we can go one more slide. So again, what the board was really doing is these two members were acting as board members. They created this page, not for personal use really, but to be board members. So let me give you an analogy. I do have a school board that was going through a period where there was really a lot of dissent in the district, and you had a split community on a lot of things. So they decided to create a thing where they would rotate board members, and they would take two board members at a time to hold what would really amount to office hours, almost as if the board is saying, okay, we know that there's members of our community who can't make it to board meetings and speak in public, or just don't feel comfortable speaking in public. So once a month, two of us will sit in the superintendent's office, and we'll invite small groups from the public to come in and talk to us. Now, let's say those board members, though, created a rule that said, we will only speak with people who have nice things to say about the school district. I think we would agree in that context that this really is a public function of the board that is being done. And because it's a public function of the board that is being done, you cannot engage in viewpoint discrimination about what's happening. And I think what the Ninth Circuit was saying is this social media page is really the equivalent of those office hours. It's just a matter of a different location. So it's like a virtual office hours as opposed to in person. And if you look at it that way, it makes sense what they held, that you really are making this about the school board. So what does this mean? And what do we think the court's going to do? Well, it's hard to predict. I can tell you this, that both cases, both the Sixth Circuit and the Ninth Circuit, relied on an older case from the Second Circuit. And that case involved former President Trump. And you may recall when Donald Trump was president, he had a Twitter page. And what happened was somebody was leaving negative comments on the then president's Twitter page and was blocked. And he brought a lawsuit. And our federal court of appeals here in New York said, you conduct official business on your Twitter page. You announce policy on the Twitter page. This is your means of communicating in your capacity as president of the United States. It's your virtual town hall. This is what you're doing. And because of that, it is official action of the government. That is, and I do recall a press conference when somebody asked the president's press secretary, are tweets policy? And the answer was yes. Um, Now, when the Trump case got to the Supreme Court, Donald Trump was no longer president. So the court dismissed that case and vacated the lower court's decision as being moot. But nonetheless, I think the same rationale is still valid. And I think that's where I would imagine that the Roberts Court, the current Supreme Court, is going to try to form consensus that takes a pragmatic look at this. And it wouldn't surprise me if they affirm the holdings of both cases. And they say the Ninth Circuit was right to say that what these board members were doing here was state action that could not be censored. And the Sixth Circuit was right to say this was really a private Facebook page. And because it's a private page, you don't have to allow critical comments on it. So that I imagine is what's going to come down. If after we get the decision from the Supreme Court, they rule in the manner that I'm guessing they will, I would be more than happy to come and present again on that. If they rule some different way, let's just forget what I just said about how I think they're going to rule. So if we can go to the next couple of slides. One more. Okay, and one more. So this is a similar case where you had, and it comes out of Georgia, and it's the most recent one of these where you had someone who was a local legislator who had a Facebook page that was very interactive, where we talk about all sorts of legislative policy in their official capacity about this. And again, blocked the negative comments and wound up losing this case. So if we can go one slide over. So again, the court, even down in Georgia, was following the same kind of reasoning as the other court cases. So again, I think that would lend some credence to the Supreme Court following this point of view. So does anyone have any questions on this part? Because then I want to talk about the board member's own, the school board's Facebook page.
Right. So Howard, in my head, it would seem to me that the easy thing to do is, if you want to communicate in this form,
Mhm.
is to have a very separate and distinct page or accounts, depending on which social media platform you use, and treat it separate and distinct. Yes?
Yes. And there was a question about this at oral argument. And one thing, one of the judges asked, well, if I put a disclaimer, I'm a trustee and I put a disclaimer on my Facebook page, and I say this is my private personal account, does that do the trick? Another judge was skeptical that standing alone would do it. So if we go back to the two board members in California, I think if they had something that said at the top personal, but everything below made it clear it wasn't, that wouldn't do the trick. But I do think if you're like the Sixth Circuit person, having the personal thing up there under when he lists his title as city manager and something in brackets that's saying, but this is my personal page, that probably adds belt and suspenders to it. But I think it's, a little dangerous to be conducting business as a single board member on your own page. And that's something I think individual trustees should think about and have discussions with their fellow board members.
But so what would come to mind as a board member for me, and again, folks, if you have a question, type it in the Q&A box and we will ask it as we go along if you have a question for Mr. Miller. But what is considered business of the board or business of the district, right? So let's say I'm posting information about when the basketball game is, the kids won the game, snow closure today. That's always a
Yeah,
big one,
that's
right?
that's I think that's innocuous. I think though, if you're going to open an interactive dialogue with the public and say, hey, what do you think we should go out with our budget? Um, how do you think we should change our own social media policy? What do you think we should do about transportation limits? What should we do? So that's what these two board members were doing.
Okay.
Really discussing the official business of the board on a social media platform. And that's something I get a little nervous about because let's say I know, like, in my town, that, and I think every other town, you have a parents of whatever the town name
Yep.
is Facebook page.
Yep.
And a lot of times you'll see really false information being posted about the schools in those pages. And the
That
problem with,
rarely happens, by the way.
yeah, well, yeah, everyone's always accurate. But it is amazing how viral, bad stuff goes and completely divorced from facts. And I have seen some board members get into trouble by trying to correct that. Sometimes it's very hard not to reveal confidential information. And then sometimes it keeps an issue alive that may have died off on its own. The fortunate thing is I have seen some other community members saying, this doesn't sound right. I think you're getting ahead of it. And I think we can accomplish similar things by using an email blast or a posting on the district's own webpage that comes from the board as an entity, as opposed from individual members, because I think it's better to speak as a collective voice.
So
And
here's a good question for you, Howard. I want to know what happens when a board member writes on a district's page, an official district's page, but by policy has community members blocked. Is this allowed? Meaning the board member has access to the district page, can comment on the district page, but the general community can't. How would that be viewed? Because they're kind of a school official, not member of the public. That's a really good question.
that's a really good question. Yeah, my answer is to call Frank. No, but anyway, I think that would be. Um, I think a court may have a problem with that, and saying, you're allowing. So there's a concept called government speech, and if you go to the next slide. um,
And I'm also getting messages that the chat is turned off, uh,
oh,
but but hopefully the Q&A box along the top is open. So please, if you see a Q&A box with a little question mark, you should be able to open that up. In the meantime, we'll work on trying to get the chat open. So go ahead, Howard.
yeah. So this is a case out of Wisconsin, but I think it's going to be applicable. Parts of it will be applicable in New York. So a district has a Facebook page. If it allows people to post on that Facebook page, and I'm glad that a lot of school districts don't allow that for the reasons that you'll get all sorts of hateful things. Um, you can't allow the pro board members, the pro school district people to post positive things, but not the negative things. So was the question you asked before about the website?
Could be, it just says district's page. Maybe I'm thinking a lot of school districts have official Facebook pages
Yeah,
or
so
official
I
Twitter.
think if you're going to allow individual board members to put their opinions on the Facebook page, I would imagine that the court would say, you open the door. And I think the rationale for that, or at least what I would say if I was the resident, individual board member has no more authority to speak for the board than anyone else. The board has a rights as a collective, and individuals have no more rights than anyone else. So that you can't do. I think where the board posts its own information as a board, because let's put it this way, I think the bigger problem would be I allow board member A, we're a board, so Bob, board, you can post on our Facebook page, you board member can, but Lorraine has a different point of view, and now she wants to post on the Facebook page. I don't think I can block her, right? So you can't block dissent at that point. So my suggestion is that you either decide your Facebook page is open or it's not.
Okay. And I am seeing we just got something in the Q&A, so just to let folks know, don't look for the chat, look for the Q&A. And Howard, here's the next question.
Okay.
If a spouse of a board member runs a Facebook page that covers education issues, is that sufficient separation from a board member? Even they may sometimes post on that page. So I guess the spouse runs the page, they're putting all the information, and occasionally the board member jumps in there and comments on the page.
I think that's still a private page.
So
I
the
don't think
spouse could block disparaging or dissenting
the spouse
remarks.
could, right. And
But
so
you would probably caution the board member as to the frequency of them commenting on that page, yes?
I wouldn't want the board member if they're gonna every once in a while, hit a like or say something in a comment, that's fine. But if the board member is using the spouse as a conduit for their own page, then that would be a problem.
So don't have a shell spouse.
Don't have yeah. That's a good way to put it. Don't have a shell spouse.
Yeah.
That is a good question. But I don't think someone could say family members can't block people just because they're family members. That would be.
And getting back to the district page question, from a best practice standpoint, if you're blocking, it's blocked for all.
I wouldn't be selective, because it just, once you allow anyone to do it, it's going to open the door to dissent. Yep. And some school districts are fine with that and don't care. That's fine.
Yep.
But where you get yourself into trouble would be when you're really blocking people with a different point of view.
And I hate to jump in, but this is the last question so you can move on. What if a district has a page, blocks comment on certain posts, and allows comments on other posts? Like, they're really splitting hairs as to when and where they're going to allow public comment.
When and where you can allow. So again, we'd have to look at what are you blocking and why. Right. Is the reason why you're blocking because people disagree with you and you don't want their disagreement showing up on your Facebook page, or is there some other reason? I would say, though, if you're going to open the door, there can be times when you block things. I think if you could block hate speech, I think you probably have an obligation to block hate speech. Where that line gets drawn is difficult. But I think you're going to have to allow a certain degree of ugly behavior when you open your forum, because you are creating so again, your Facebook page becomes, like a public park then, where you're allowing people to talk. And just because you don't like what they have to say, doesn't give you the right to block it.
All right. And Howard, here's another question. District has push-only Facebook page on all posts, meaning comments are disabled. Twitter seems more problematic because one can't prevent others from commenting, sharing, and quoting tweets. So thoughts about Twitter accounts, again, it seems a little, if you're going to try to restrict any Twitter comments, it's a little tougher, I guess.
Yeah. So,
so as a board member, you're probably not going to run into trouble because people have means to comment dissenting views
on your tweets.
Yeah. Okay. And David also followed up with what if the spouse thinks the board member is a shell board member? That'll be another workshop and webinar we do later on. And is it okay for a board member to comment on Facebook under a page that states parents, teachers of school district, but member has community members blocked? So I guess if it's a parent or teacher page and a board member comments on it and that page blocks other people, I would seem to think that's enough separation for a board member. You don't control that page.
Yeah, so that page is a private page. So you can comment on things in the ordinary course. Where, and I alluded to this earlier, where I'd be cautious is the temptation where people say things that just aren't accurate, and you could wind up jumping in down a rabbit hole with them. And I just have seen that go in a bad direction. So what I would suggest you do when you see these comments, so sometimes there's just an incident. It could be a hate incident that goes viral in 2 seconds. And you see people posting on the parents' page that are distorting what actually happened. I'd say rather than trying to jump in as individuals into that mess, I would use the board's methods of communications to speak as a united voice and get your
Let
information
the
out.
district post something on its official page as
Or
official district statement if it warrants clarification.
if warrants clarification, or do an email blast.
Yeah.
What I have seen districts try to do also when they know something is going to go viral any second, they try to get out ahead of it, get their correct story out beforehand. And that sometimes meets with success and sometimes doesn't, because sometimes the board will be constrained not to give certain information out. Let's say there's an issues involving students, you may be barred from confidentiality. So what I have seen is an email blast go out. Then on the parents' Facebook page, they say, oh, they're not giving us information, not telling us anything. But fortunately, in those situations, I do every once in a while see another member of the community say they can't. That's why they're not telling you that. If it was your child involved with this, would you want them blabbing this all over the place? So
And
I
another thing
think
I
that,
would always caution,
mm,
my newer board members with and board members in general is, sometimes if you're posting things that could become a legal matter down the road,
mhm,
those posts could be part of a lawsuit that you could open up exposure for a district. So less said is always better.
yes, yes. And again, sometimes you post something in good faith to try to correct something, and then your words get completely distorted. So those are just the reality of what we're living with these days.
All right. And here's another question. What are your thoughts, Howard, about board member number one blocking board member number two from seeing any of member number one's posts?
On their own page or on what
I'm
page?
assuming on their own page if they're posting information.
Yeah, yeah. Yeah, it doesn't foster collegiality. But there
A
are
board retreat might be in order.
yeah,
Absolutely.
you may want to have NSBA do a retreat. But look, I can see where there's just board members that just don't get along with each other, and one doesn't want the other one on their page and doesn't want them commenting on their page. And that's your private space.
But again, if your page is viewed as a quasi official government
Then
page,
then you have a
then
problem.
you're violating that other board member's rights as well,
That
because as
is
an
that is
individual
true.
board member,
So
you're acting as an individual.
in the ordinary course, if you just have your own private space Facebook page and you do what normal people do on their Facebook page, you're posting about your life events, your kids, all these things. But there's a board member who you just don't get along with and you don't want them looking at your stuff, you can block them.
Yeah.
Yeah, you don't lose your rights in that regard to be a private citizen.
Okay. Good questions, folks. All right, Howard.
Okay, let's go to the next slide. One more. Okay, this is a very interesting case. Now, it came up in the context of, oh wait, 1 second. It came up in the context of posters in a school. But I'm going to tell you what happened, and then let's talk about what would happen if this was on the district's own website. Okay, so you had a school district that authorized posters after this was after the George Floyd tragedy, and authorized posters around the buildings of Black Lives Matter. And this was other people then said, and we can go to the next slide actually. Oh, sorry, go back. Sorry, Bob.
That's okay.
So, and other people then said, if you're going to allow Black Lives Matter posters, or you district are going to display Black Lives Matter posters, then we get to display other things. We residents get to say something else. And the court said, no, you don't. Because the hallway is controlled by the school district, and the school district is entitled to what we call government speech. So the school district as a corporate body can create its own view of something. So it can have Black Lives Matter on in hallway posters and not open the forum for everyone else. Now, so let's take that to a school district's webpage as well. So if after George Floyd, they put Black Lives Matter logo on a school district's webpage, and this is something the board wanted to do, does the board lose control of its webpage such that other people can say something different? And on this analysis, no. So some of you may recall that, there was a horrific attacks in Israel on October 7th. Some school districts sent out letters to the community, which they then reposted on their own web pages about what happened. Now, when they did that, does that mean residents would have the right to say, I want to post about Free Palestine on your website? And again, the answer to that is no, because you control your web page. You are not allowing third parties to come in and speak on your web page. It's just the district's web page, and only the district controls what goes there and doesn't allow other people to post on the web page. Let's change the facts of this, though, a little bit. Let's say instead of the district displaying the posters, individual teachers in their classroom decided on their own accord they were going to post Black Lives Matter posters in their classrooms. And the school district was then fine with that. And now another teacher wants to post a Blue Lives Matter poster in their classroom. Would that teacher have the right to do that? And the answer to that question is yes, they would. The reason being is that if you're going to allow now third parties, your teachers, to engage in speech in their own classrooms, then you can't discriminate against the viewpoint of whether it's Black Lives Matter or Blue Lives Matter. Same thing with, and I had this come up at another NSSBA conference.
So here's a question I think that really is right on point. So if Black Lives Matter posters are okay, what is the issue with displaying progressive pride flags? So again, the question in my head is, if the district, the governance team of the district said, okay, we are going to authorize BLM to be on our website, that's the action of the board or the action of the district. But what individual teachers are doing in the classroom then opens it up to a
Other
variety of voices because the teachers are not the district.
Exactly.
Okay.
Exactly. So we had this recently come up with another district where a pride flag was put outside of the counseling center in a high school. And the purpose of that, and it would, again, with the under the auspices of the school district itself, not individual staff members. The purpose of that was to say, this is a safe space, no matter what, how you identify, no matter who you are, you can come here and it's safe. Now let's say then a staff member with a different point of view about that movement wanted to post something negative to that or the opposite of that. The answer would be no, again, because it's government speech. But, and this is where it gets a little dicey. What we don't know, because I haven't seen a case like this, is now let's say the staff member had put a pride flag in their classroom, and another staff member wants to put a slogan to the effect that that is immoral or whatever. That would get very tricky because On one hand, you could say the other staff member who was posting something contrary would be a DASA violation and make it so kids feel discriminated against. So the way we've dealt with the pride flag is try to make that government speech rather than having that fight, whether the pride flag is political movement or whether the pride flag represents just a safety sign for children. So hopefully, none of you on this call will ever be the test case for that fight. But what we've tried to do with the flag is to try to make it again something that was signed on by the school district itself, as opposed to individual speech of staff members. And you may recall during COVID, um, where I remember one time driving up to to my own school district, and security guards were having warring face masks of different groups. And at some point you just say, I just want to drop my kid off. I don't want to see all of this. And
Right.
I think the answer to some places was, hey, don't wear political things on your mask. You just wear a plain mask. So it could be that once you open the door to allowing individual staff members to post whatever they want in their classrooms, you are creating a forum for anything, and that includes religious speech. So I did get the question, if you teacher has a bookshelves of all their personal favorites, their own individual favorite novels. Can another teacher have the Bible there? Well, yeah, they can. You open the door for that. And you can't discriminate because somebody's favorite book is the Bible.
Mm.
So these are all issues that we grapple with. Any
Slippery
questions?
slope for sure.
It is. Okay, so what I did was we did a little internet search, and I don't know if any of you have seen Jay Warona speak at law conferences, but he always says that he does, your goal in attending one of his conferences is to not be one of the cases listed in his outline. And I think the same would hold true, is that you never want to be the newspaper article that appears in some lawyer's PowerPoint. But I will send, I'm just going to share, we have a few minutes, just a couple of slides that are out there. So if we could go forward. So you have a school board member resigns after a Facebook post that was pretty hateful, calling the Israeli Defense Force a terrorist organization. So again, you do have your own personal speech, but you have to remember that there is a public watching everything you do. And whether a school board could really remove you for something like this, I'm not so sure. But the public pressure on you could be tremendous. Just if we can cruise through a couple more of
Right.
these.
Free speech doesn't free you of the consequences of
No,
the
it does
words of that
not. It
speech.
does not. So next slide. So go one more. Yeah. So again, these are more racist in tone. I do believe that if you're going to post, and again, I doubt anyone on this platform would ever do this, but to the extent that there are board members that really post things that are racist, as opposed to a political opinion, I do think that at some point would be a ground to remove a board member. And that's something to be mindful of. And again, you want to be careful with what you post. And and I think we're seeing this in the public pressure about things. And since October 7th, you have seen people be fired, have admissions offers to colleges, to prestigious universities, revoked. There was a student who had a scholarship from Long Island to NYU. You think about how much that's worth,
Mhm.
and was caught on video doing something pretty awful and had it revoked. That could be in the neighborhood of $300,000 worth of an education that you just threw out the window.
Right.
We
You have
also
your right to
see
free speech, and they have their right to
they
say
have their
we're
right
not.
too,
Yeah.
and again, you post something like this, maybe the school itself can't do anything, but your employer can. Remember, the First Amendment is only in the public sector. The First Amendment does not apply to private employers. So that is something I've sometimes seen that post on my own, looking at Twitter and looking at these things, and they're saying, well, how could an employer fire somebody for what they did on social media? Because they're not bound by the First Amendment. It doesn't apply to them. So things to be mindful of.
So always keep this in mind. How does your post or your tweet look if it was a Newsday headline?
That is a good way to look at it. Um, if we could fast forward just a few, I want to get and Bob, I'll give you an indicate. Keep, if you don't mind, keep going. Yeah, and again, see, these are just more tweets, all these things. Okay, this one here, and this may be something you might want to Google on your own. Where they started to create their own social media policy about what's said on social media. If we can go one more. And I think these kind of things are valuable in here. Again, we're not looking to quash anyone's own First Amendment speech, but it's good to be mindful of what your fellow board members may expect of you. And keeping in mind that you are role models for everyone in the district, may not be a bad idea. Maybe you don't need a formal policy on this, but to have this kind of discussion about what you all post on social media, and whether that damages the reputation of the school district or otherwise causes dissent within your own boards. So with that, I will
And
stop. And
distrust as well.
mistrust, that's true. So I can stop here and just take any more questions anyone has.
All right. I think again, getting to a best practice standpoint, because the way we communicate today is very different than it was even 5, 7 years ago, 10
Yeah.
years ago, that if you are inclined and you want to share information and you, because as a board member too, right, we're elected officials, you want to be out there, you want people to know your name and you want them to know that you're a board member. Make sure it's a separate and distinct page from your personal page,
Right.
and know that you're going to open it up to the haters and the supporters and just let it fly, right? If it doesn't apply, let it fly. But make sure it's a separate, distinct page so they're not ridiculing you because you're a Raiders fan or a Viking fan or, wow, your vacation picture looks stupid or whatever. Have a very separate and distinct page as a school board member where you could share the district information, and either it's comments for all or don't allow any comments. So it's an all or nothing sum game type of thing. Yes, Howard?
Yeah, so one thing that may get lost a little bit in this is that social media can be a wonderful thing.
Yeah.
I did, the superintendent for the Menacing School District made a comment to me before I spoke at the School Boards Association. He said, our district's Facebook page and our website is like our daily newspaper. That's how we let everyone know what's going on. And a lot of times people focus on just negatives. And these platforms are a way to say to the community, we are doing a lot of really good things here. And sometimes I have to say, just speaking to my neighbors, they really don't know what's going on with the school. And it'd be nice. It's a great way to get your message out. And
Yeah.
again, typically your website is going to be something where you control the message and you can put things out there that let people know that here are the initiatives you're doing. Here are the accomplishments of all your students.
Right. The 50
And
Regeneron students from Long Island, from all the districts across Nassau and Suffolk, here they are.
amazing.
Like, celebrate the
Yeah.
successes, celebrate the achievements. Yeah.
Yeah. And I do think sometimes that gets lost. As I know I don't want to be a connoisseur of the obvious here. We certainly live in divided times. And sometimes I've been at board meetings and people are mad about like real minutia and they're missing like the broader picture. You have school districts that test scores went through the roofs, their graduation rates went through the roofs, and you're fighting about some little thing. And I don't know whether it's just that people aren't aware of the accomplishments or it's just so far down on their radar, it's not resonating.
I think it's a little bit of both too, Howard. You know, sometimes we stink at marketing our schools and how good they are and what we're doing, and other times it doesn't matter what you're doing. If that's an issue for me, it's an issue for me, and I don't care about anything else. I'm only focused on
Yeah.
this, and it gets back to how you deal with confrontation and contentious board meetings or contentious conversations online. But you're right; it is a wonderful tool. I had Newsday reach out to me recently and say, "Hey, we're trying to streamline notification for closures due to weather. You
Mhm.
know, can we do something?" And you know, it occurred to me that most people aren't watching News 12 for the scrolling banner anymore. Or back in the day, we used to hear it on the radio, or they're going to go to Newsday. They're going to go to the school district website or official Facebook page or Twitter, and it's going to be announced there before anywhere else. I mean, that's again
Yeah.
how we communicate today to get information out is very very different. So use it as a tool, but be cautious that you're not violating somebody's rights and you're not venturing over into something that could set you up for exposure. And I think the conversation with individual board members, what you're posting on social media, is definitely a worthy conversation of the board and the governance team as a whole. Right? If you have board retreats, this is definitely a topic of conversation. What are our own expectations for our team? And it could vary district to district. Some boards are going to be like, yeah, we're okay with it. Other boards are going to be like, yeah, you know what? Let's take this policy and let's go this route. So I think that's a great conversation for board members to have as a governance team together with your superintendent. And again, when it comes to messaging for the district as a whole, you want to work as a governance team so that it's one unified message. Now, if there's dissension within the board, that's a different thing. That should be handled at the board table, not, as you alluded to very early on in this presentation, not on the playground for idiots, which can then be interpreted as social
No,
media and the World Wide
no,
Web.
yeah. So yeah, I would agree with all of that.
Okay. Any other questions for Mr. Miller? And because we are very mindful of your time, we try to design our webinars to be chock full of information, but concise and mindful of everybody's personal time. And we're almost getting to our bewitching hour of our 60-minute bell to bell here of the webinar. Do you have any other questions that you want to post in the Q&A? We had some really good interaction there, Howard. And before, you know, folks start jumping off or whatever, I want to thank you for bringing your expertise and your opinion and
Anytime.
your values into this conversation. And um, Howard Miller has also agreed that this will not be a one-off webinar. We may do another one, maybe not this year, maybe early next year, to complement what Jay Warona and the New York State School Board Association does on an annual basis for us as well. So, you know, as timely topics come up, we may call on you again, Howard, to say, hey, can you give us some legal guidance or what's going on at the Supreme Court? So I always find pending court cases fascinating.
Yeah, me too.
All
Okay,
right.
thank you so much.
Thank you. So, seeing no other questions coming in on the Q&A, we want to thank you for joining us once again. Again, we have sent information to your district clerks about our annual joint conference on January 25th at the Hilton in Huntington. We got an action-packed program there, and also our next free online webinar is going to be March 12th. Effective communications during a crisis. Avoid creating a crisis within a crisis with poor communication. So that's going to be another one with an expert in the communication and PR field, and they specialize with school districts as well. So that's going to be in March. No information has been sent out on registration yet. Don't bother your district clerks with that. Just save the date. And again, we will be sending out this recording to everybody that registered. We had over 115 people register. I know about 30% of that signed on tonight. So if you registered, you'll be getting a copy of this recording as soon as we kind of condense it and clean it up for you. And Howard, once again, thank you very,
Thank
very
you,
much.
Bob. Thank you, everyone. And again, Happy New Year, notwithstanding Mr. David, but everyone be well. And if anyone has any questions, you can always email me at hmiller@bsk.com, and I'll be happy to answer them.
All right. Everybody have a great
Okay.
night. We'll be sending out a brief survey about this event so that you can give us your feedback on it and then also suggest other future webinars for us. So please give us your responses when you get that survey in the next couple of days. Everybody have a great evening, and we'll talk to you soon.